Continuing our discussion on the provisions of the Nigerian Data Protection Act 2023. So today we'll have to go into considering where purpose will play a vital role in determining the applicability of the provisions of the Act. Previously in our video, we have talked about the 8 objectives for enacting the Act. We have also considered 3 conditions that will exist to create room and determine who will come under the provisions of the Act. But today, let us consider where purpose or intention will determine grounds for application or the applicability of the Act. Generally, under the Act, where the intention or the purpose for processing an individual's private data is for personal use or household purposes, family purposes, it means that the provisions of this Act will not be applicable to such scenario. But even though the Act has said that it is not applicable where processing is for personal use, you must also ensure that in the process of carrying out or collecting or processing that personal data, that you do not also violate the rights and freedom guaranteed under the Constitution of the Federal Republic of Nigeria. Going further, there are obligations that have been set out under Part 5 of the Act relating to what is expected of a data controller or a data processor. So subject to these provisions of obligations, limitations set under the Constitution, as well as rights and freedom guaranteed under the Constitution, the controller or the processor is not expected to carry out these obligations other than the ones set out in sections 24, section 25, section 32, and section 40. So under the Act, there are obligations like seeking consent, like doing risk data impact assessment. So when it comes to 5 different scenarios, the law says that these other duties are not expected. Nobody is expecting a data controller to fulfill these duties or execute these duties that are provided under Part 5 of the Act. And the Act has given us 5 different scenarios. One of such is where it is a competent authority in the country, maybe like the government, a government department, or the court that is actually processing that personal information for the purpose of addressing or taking care of a national health emergency. A second scenario where the data controller is not expected to execute his obligations under Part 5, other than those I have earlier mentioned that are provided under Section 24, 25, 32, and 40 of the Act, is where it is for the purpose of either trying to investigate or to prevent the commission of a crime. In such a case, there is no need coming to seek for consent. There's no need coming to ensure that you have done your risk impact assessment. Why? Because you are in a process of carrying out an investigation or prosecuting a crime. Another scenario that he is not also under obligation is where it relates to national security. Maybe there is chaos in the state already, and it is important to extract, or it is important to process such information in order to arrest the condition or the situation in the country. The fourth scenario, where he would not be expected to execute such obligation, is also where it relates to issues of public interest, journalism, artistic work, literacy work, and all of that. Lastly, where it also has to do with claims. You want to process your claims before a court or before an administrative panel that has been set up. It also means that such obligation of trying to seek consent, of trying to do risk assessment and all that, will not also be applicable to such a data processor or a data controller. So that is the provision of our law. We are always here to give you premium legal tips to help you make informed decisions